you are a foreign investor planning to enter the Vietnamese market, one of the first legal questions you must answer is whether you can own 100% of your company or whether you need a local partner. Vietnam has opened many sectors to foreign ownership, but restrictions still apply in certain industries. Understanding these rules is critical to choosing the right investment structure, avoiding compliance issues, and protecting your legal position. In this video, we explain how foreign ownership restrictions work in Vietnam and what you need to watch out for when planning your market entry. Vietnam's legal system on foreign investment is based on the law on investment and international treaties such as the country's WTO commitments. These commitments define which sectors are open to foreign investment and to what extent. Sectors not covered by the WTO schedule may be subject to domestic laws or conditional approvals. In addition, Vietnam has bilateral trade agreements and free trade agreements that may offer more favorable treatment to investors from specific countries. Therefore, determining the applicable rules requires reviewing multiple legal sources. Vietnam classifies business sectors into three categories: unconditionally open, conditional, and prohibited. In unconditionally open sectors, foreign investors can hold up to 100% ownership without restrictions. Conditional sectors require specific licenses, approvals, or conditions to be met before investment is allowed. Prohibited sectors, such as narcotics, certain chemicals, and national defense activities, are completely closed to both foreign and domestic private investors. Most M&A transactions fall under the first two categories, making proper classification a critical step. Sectors commonly subject to foreign ownership limits or conditions include banking, education, logistics, real estate, telecommunications, advertising, travel services, and publishing. In these industries, foreign investors may be limited to a maximum equity percentage, required to enter joint ventures with Vietnamese partners, or restricted in terms of management rights. For example, in road transport services, foreign ownership is limited to 51%. In logistics, different subsectors such as freight forwarding, warehousing, and customs brokerage each have different thresholds and licensing requirements. In M&A deals, the rules on foreign ownership also apply when acquiring existing companies. If the target company operates in a conditional sector, the foreign buyer must either stay within the allowed ownership cap or seek approval to exceed it. In some cases, acquisition above the threshold is possible but subject to prior approval from the Ministry of Finance or other relevant authorities. If the target operates in multiple sectors, the most restrictive condition typically applies. This makes legal structuring and due diligence essential before signing the deal. One overlooked issue is that foreign ownership restrictions are often linked to the company's registered business lines, not just its actual operations. If a Vietnamese company has declared business lines that are restricted, a foreign buyer may face limits or need to restructure the scope of business. Therefore, legal due diligence must include a careful review of the target's business registration certificate, as well as any sub-licenses or sector-specific approvals. Failure to align the declared scope with legal thresholds can invalidate post-closing operations. In some situations, investors have used nominee arrangements or silent partnerships to bypass foreign ownership limits. However, these structures are legally risky and increasingly monitored by regulators. A better approach is to work within the legal framework through joint ventures, layered holding structures, or by carving out restricted business lines. Vietnamese law also allows certain approvals on a case-by-case basis depending on the investor's reputation, track record, and investment size. Legal structuring must be handled carefully to avoid future compliance risks. Foreign investors acquiring capital in a Vietnamese company may be required to obtain what is known as M&A approval from the Department of Finance. This is separate from merger filing under competition law. M&A approval is required when the acquisition results in foreign ownership exceeding 50% or if the company operates in a conditional sector. The application must include detailed documentation about the investor, the transaction, and the company's business scope. Without this approval, the transaction may not be legally recognized. Foreign ownership restrictions can also affect governance rights, voting power, and profit distribution. In joint ventures, the foreign investor may hold a minority or capped equity stake and must negotiate contractual protections to safeguard its interests. These may include veto rights, board representation, dividend preferences, or buyout options. Legal documents must be carefully drafted to balance compliance with practical control over the business. At LTS Law, we help foreign investors assess ownership restrictions, navigate regulatory approvals, and structure transactions that comply with Vietnamese law while achieving strategic goals. We analyze sector-specific rules, identify risks, draft legal documents, and liaise with government authorities to ensure smooth market entry. Our experience spans logistics, education, manufacturing, and other sectors where foreign ownership rules must be understood and managed from day one. Before investing in a Vietnamese company, make sure you know what you can legally own and what restrictions apply. Contact LTS Law or visit lts.com.vn to schedule a consultation. With the right legal guidance, you can invest in Vietnam with clarity, compliance, and confidence.